Welcome to Probate Notes, your go-to podcast for mastering California probate law. Hosted by Sam Price, a certified specialist in estate planning, trust, and probate law, and author of the 6-stage probate process, each episode delivers expert insights, actionable strategies, and real-world solutions, from understanding probate processes to navigating probate litigation. Join Sam and his special guests as they simplify probate practice, answer listener questions, and elevate your expertise.
Hi there, folks. This is Sam Price with Probate Notes. Thanks for tuning in today. And I have a real treat for us because we have an attorney from Silicon Valley that's going to be able to give us some really good insights about international issues in probate matters. So I want to welcome Janet Brewer to the podcast. Hi there, Janet. Thank you for being on today.
Sam. Thanks for having me.
Absolutely. I just want to get started with learning a little bit about you and where you're from and your background.
Well, I grew up in the Chicago suburbs, moved away when I went to college in Wisconsin, and came back for a year after that before I started law school. Then I moved to Denver for law school and was hired actually by Hewlett-Packard Company out in Palo Alto after law school. So moved to California and haven't looked back.
What type of work were you? That's interesting. What did you do for HP?
I was a corporate attorney. I was on the legal staff. Actually, they specifically hired me because I had gone to university. Well, there were only 2 law schools in Colorado. So I went to one of the 2 law schools. They were just forming a big presence in Colorado. They had a big sales office there and they had 2 manufacturing plants out there. And so they wanted somebody that was familiar with Colorado law who could advise on, Colorado issues as they arose. So
interesting. You were kind of in the right place at the right time.
Yep. Actually, I probably shouldn't say this, but very much so. It was prior to when Hewlett-Packard, they didn't even have a personal computer at the time. So the only people that had ever heard of them were engineers, because they started off doing oscilloscopes and surveying equipment and very, very technical things. And because they were so poorly known, basically, I don't know, I can't speak for who signed up at University of Colorado, but only 2 of us signed up for the interview at the University of Denver. So.
Wow. Did you both get hired or only you?
Nope, just me.
Just you.
Just me. Yep.
But it sounds like you were there at an exciting time.
It was very interesting. I actually was there when they first broke into the Fortune 100 list. So up until that time, they had been mostly a local company. They had a subsidiary in Geneva and whatnot, but they were really very much Palo Alto centered.
And you kind of been there through this whole transformation of what Silicon Valley is today. It sounds like you were there from like the beginning.
Well, the beginning was really in the 50s and 60s. I know I look old, but I'm not quite that old.
I'm sorry. I didn't mean it that way. That's not what I was trying to say. But you've been in Silicon Valley ever since. And tell me a little bit about why did you go to law school? What made you interested in the law?
So I don't have a really good answer for that, but you've known me for a while. I'm kind of blunt and to the point. Basically, in high school, I was told that I was argumentative. And he should be a lawyer.
No, I wasn't. That's the answer, right?
No, I wasn't.
Yeah.
And back in the day, I graduated from college and got a job working for a company as a secretary when a guy that I had trounced in every class got a job as a junior executive. And meeting me basically said, well, if I go to law school, I might not be able to get a job, but at least I can hang out my own shingle. So that was my well-reasoned approach to getting into law.
And so after you left Hewlett-Packard, what did you do?
I actually spent a fair amount of time in corporate work. After I left HP, I became general counsel of Hills Brothers Coffee. And
what? That's incredible.
Yeah, that was a really interesting time. It's not fit for a podcast, but we can have a drink sometime and discuss that one.
Would love to.
And then after that, I went to a company that basically had just recently gone public as their general counsel. And then went to, we're talking back in the day. So the company that I went to that had just recently gone public was the first company to take a 5 megabyte hard drive and marry it to an Apple II computer. So they were very high tech. And then I left them and I went to.
I'm so sorry because we're recording this audio and video. And so what you did was you kind of made this hand gesture to show us the size of this 5 megabyte hard drive. And it looked like, I don't know, a bread box, a microwave.
The size of a suitcase, the size of a bread box.
That's
a microwave, actually, probably more than a bread box.
And that was a 5 megabyte hard drive.
And that was 5 megabyte. Yep.
Okay.
Back in the day when everybody, remember floppies only took like 144. God, I can't even remember what
were they
called.
Kilobytes at that time? I can't even remember.
I think they were kilobytes. Yeah. So
but then there was
5 megabytes was 50 times bigger than a floppy.
Yeah, but I remember seeing 7.25 inch floppies, and then they went 5.5 or something like that. Or was it 7.5
and then they went like 3 something. I can't remember anymore.
Mm-hmm.
But, yeah. So and then I went to a company that basically was involved in the internet when we had a modem that was basically, instead of having a 600 bit per second modem, we went all the way up to, I think it was 9,000 bits per second.
Now, was this dial-up or was this?
It was pretty much yeah.
Yeah. Right.
Yeah.
Lightning fast speed at that time.
Lightning fast speed at the time. You got it.
Yeah.
Yep.
And so you're going through your career, you're doing a lot of corporate work, but at some point you said, you know what, I'm going to be my own boss. I'm going to form my own firm. And at that time, did you go into corporate work or did you do something else?
So I actually went to work for a small law firm up in the city that the principal attorney was a JD CPA.
And the city of San Francisco.
City of San Francisco, yeah.
Mm-hmm.
And he hired me to handle his corporate clients because they were doing all the estate planning for their clients, but they were referring out all of the corporate work. And he wanted to capture the corporate work, but he told me, I don't have enough corporate business to keep you busy full time doing that. So you're going to have to basically go to school and learn about estate planning. So he sent me to get a master's degree in tax law. And I did it. The firm actually broke up a couple of years after I started with him. And that's actually when I decided to go out on my own. And I learned, fairly quickly that it was much more fun doing estate planning for people than it was doing the corporate work. It was much more satisfying.
Where did you get your LLM?
Golden Gate University, which a lot of the they had night school LLM programs. So a lot of people who couldn't afford to take the time off to go to Miami or New York would go to Golden Gate, get their tax degrees there.
Yeah. And your LLM's in taxation. Is that right?
Correct.
Okay. Gotcha. Yeah. And so have you found it really useful in the work that you do?
Quite frankly, I think it's essential. I do have a lot of clients who have taxable issues, and even the ones that don't, I think it's important that you at least have tax in the back of your mind, that there may be a tax issue lingering there, and that you need to be aware of it so that you can deal with it.
No, that's really good. That's important. And so now that if someone were wanting to get in touch with you and your firm, what is the very best way for someone to contact you?
We have forms on the website, which they can certainly fill out, or they can telephone the office. My intake person would talk to them, see if they're a good fit, see if it's something we can help them with. And if so, then she would set up an appointment where, they and I could talk, or they could talk to my paralegal, depending upon what the nature of the problem was.
What is that website?
It's www.calprobate.com.
Calprobate.com. I love it. That's fantastic. You got that early. That's a good one.
I did.
Yeah. So calprobate.com, or what's the phone number that someone would call your office?
650-325-8276. And I believe it's press 1 for new clients is my recollection. I haven't called in for a while myself. So
yeah, you haven't hired yourself in a while. Okay. It's been a bit. It's been a minute. Let's dive into a little bit of tax issues because
Sure.
there are special tax issues. Let's first talk about and the word tax can mean so many different things. So I want to get more specific. Most estates don't have an estate tax issue because the estate tax exemption amount is so high, and California has abolished the estate tax. And so right now, someone could give away up to, how much is the exemption for 2025?
For 2025, it's $13,990,000. I heard that it's going to be going to an even $15 million as of January 1st. So so for a married couple, it's $29 million. What is that? $800 and something $1,000, and currently, and it's going to be $30 million next year.
It's a lot of money. I don't know. You probably do, but I don't know anybody with this kind of money.
I do have clients that are north of that. But what people, and this actually gets into the topic, what people fail to recognize is that those are the numbers for U.S. citizens and U.S. green card holders who do not intend to leave the United States. If you are a non-resident alien, if you're working here on a visa, for example, or you're a college student here on a student visa, the exemption drops to $60,000 per person.
Big difference, $60,000 to almost $14 million.
Yep.
You said non-resident alien. What is a non-resident alien?
So the $60,000 exemption applies to both non-resident aliens and resident aliens who are not green card holders or who are not U.S. citizens. So, for example, someone who is here on a work permit or on a student visa is a resident alien, but unless they've applied for a green card, they're not a green card holder, and obviously they're also not a citizen. A non-resident alien is a person who does not live in the United States and does not have the right to work or remain in the United States. So, for example, if I were a U.S. citizen and my spouse, or even a green card holder, if I come over to the United States to work, my spouse accompanies me, and he's not going to work in the United States. He would be a resident alien, but could, if he decided to stay back in whatever our home country was, he would be a non-resident alien and just be coming over on like a tourist visa every so often to see me. So it is primarily someone who neither works nor lives in the United States and has not filled out the paperwork and been accepted as a green card holder or who is not a U.S. citizen.
Now, this might be confusing about there's a presence test for the income tax to apply. And it's, basic, there's a number of days, it's 183 days or whatever it is,
right.
For a number of years. Does that apply here to whether or not you're a resident? And does that matter to the estate tax?
So this is where things get a little slippery. The short answer is no, not really. For estate and gift tax purposes, we don't look at residence as much as we look at the concept of domicile, which you might remember from your first year civil procedure class in law school. And the distinction, or a distinction, is that you can have many places in which you reside. You can have a residence in California, you can have a residence in Hawaii, you can have your place in Paris.
Sounds nice.
Yeah. The little island that you bought off the coast of Caribbean.
Sure,
Greece. All of those are your residences, but you only have one domicile. And the domicile is the place that you consider your home. So you could live, even as a green card holder, you could live in the United States for 30 years. But if you still think of that little island off of the coast of Belize as your home, you are not a domiciliary of the United States. And technically, you only qualify for that $60,000 exemption.
Is this an intent requirement, or is this, what is domiciliary or domicile?
Domiciliary, yeah.
Yeah.
Yeah, it is a question of intent. Where do you intend to live? Where do you intend to die? even if you don't live there at the present, it's, what do you really consider your home? And it is a slippery concept. I mean, there have been cases, obviously these days, well, I guess I need to strike that. I was going to say the IRS can't go after you, but I think I'd get in trouble for that. So I might take that one out. Just domicile is a slippery concept. There's I guess the landmark case is a gentleman who, and this goes back to like the 30s or the 40s. He had been in the United States for years and years and years. He had a business in the United States. His wife and I think his kids were in the United States. He went back to, I believe it was Iran, to visit his dying mother. And he got sick while he was there and couldn't travel back to the U.S. and ended up dying in Iran. He had a substantial estate by 20s or 30s or 40s standards. And when his estate was being settled, the IRS basically said, wait a minute, you are not, or he was not a domiciliary of the United States. So he's only got this $60,000 exemption. And it went all the way up to the Supreme Court. And the attorneys had to lay out a case for why he was a domiciliary of the United States. And of course, the IRS wanted its tax money. So they were laying out all of the reasons why he was not. He did end up, or his family did end up, proving that he was a domiciliary because he intended to return to the U.S. He was just prevented from doing so because he got sick.
Right. No, that understandable. And so there was actually a court case about this.
Oh, yeah.
Yeah. Okay. So when it comes to someone who is can we use the term non-resident alien, but it applies to resident aliens as well, doesn't it? It's the same rule.
It can apply to resident aliens. I mean, one of the questions that when I'm dealing with a couple where one or both of them is a green card holder, I ask them the question, if something happened to your spouse, would you stay in the United States or would you leave? And if they say, I would leave, they're technically not domiciliaries of the United States, right? Because their intent is not to stay here. Now, typically, once people have kids and the kids have grown up in the U.S., and more importantly, the grandkids are in the U.S., people don't tend to leave the United States. But I've had clients who've said, look, I can go back to China or I can go back to Vietnam or, whatever the country is, and I can get someone to take care of me full time for $300 a month, and it'll be great care. I can't afford to do something like that in the U.S. So I plan to leave. I don't want to be a burden to my kids.
That makes a lot of sense too. And that's really understandable. But I think given the choice, I think most people are going to have the intent to pay the least amount of tax, no matter where they consider home. Right. So, I mean, yeah, but given the right question, they might say, oh, you know what? Oh, I tend to be here, right here in the U.S. and get that full exemption amount.
Well, and quite frankly, because of the way that the test works, what they say today doesn't matter. It's what is it at the time that they die.
Mm.
So, you can't really plan for someone changing their mind 10 years from now or 20 years from now. You can make them aware of what the issues are, but they may fully intend to stay in the United States today. And for whatever reason, they change their mind, 10 years or 15 years from now. Or they may fully intend to leave today and change their mind because, again, now they've got grandkids here or, the situation has changed.
And I think there's always that weird case, but I think for most people, this is really clear. Where is their domicile? They're going to have, if for a non-resident alien, it's not here. So it's not in the US. It's the question really comes with people that are resident aliens. So they're living in the United States and there's some type of residency here without a green card, but they are not citizens of the US.
Correct.
That's where the ambiguity comes in.
Yeah, exactly.
So what is the problem? Let's say you've got someone who's a non-resident alien and they own a house in California. Walk me through what is the problem with that on the estate tax side?
Well, on the estate tax side, as I jokingly and not so jokingly tell people in my area, which is Los Altos, which I actually just learned is like the fourth most expensive community in the United States, according to one of the surveys that I saw. You can't buy a garage for less than $5 million. So, so if they, even if they've got a rather small house, you're probably looking at a house that's worth at least $1 million. And roughly the estate tax on $1 million estate, if your exemption is only $60,000, is $345,800. So that $1 million house could come with a $346,000 estate tax bill attached to it.
That's a lot of money.
Yeah.
Yeah.
It is.
That's a third of your house is gone. Never mind the case or what have you.
Correct.
Right.
Correct. And the other issue is if they, I know you know these form numbers, but if you have to do a 706 NA, which is 706 for non-resident aliens, if you actually look at the rules, you're not allowed to deduct things like mortgage interest and all of the other things that we would think of that we deduct routinely on these estate tax returns, unless you disclose your worldwide assets. Now, if you're, a young kid who is just here because they got an engineering job and they're hoping to make it big on stock options or something like that, maybe they don't have a lot of worldwide assets, but, and frankly, this probably comes more into play when I'm dealing with non-resident aliens than it does for resident aliens. But again, in this area, pre-COVID, we had a lot of bus tours of people coming from Asian countries, literally, 40 or 50 at a time. And the real estate agents would take them on tours of houses to buy. And so they were buying, as rental properties, they were buying these $1 million and $2 million and $3 million and $4 million houses. If something happened to them, their family had a choice to make. Do we disclose worldwide assets so that we can take advantage of the deductions, or do we just disclose the assets that are in the United States? Now, a green card holder or a citizen doesn't have that luxury, but if you are a non-resident or a non-green card holder or a non-citizen, the good news from a tax perspective is that you are only required to report assets that are deemed to have what is called a U.S. Situs. So you might have to report your $2 million house in Silicon Valley, but you wouldn't have to report your $10 million ski lodge in St. Basil.
I want to ask maybe a little bit about the mechanics of being able to do this, because a 706, IRS Form 706 is an estate tax return, and a 706 NA is for a non-resident alien, an estate tax return for a non-resident alien. But if you're a non-resident alien, you don't have a social security number.
Correct.
So how do you file a 706 with the IRS?
Well, typically you would have, best case scenario, you would have to get what's called an ITIN. It stands for International Taxpayer Identification Number. It is a social security equivalent that is specifically designed for people who do not meet the requirements for getting a social security number, but who have financial interests in the United States. If you haven't gotten one prior to your death, it can be a problem. I'm actually probating an estate of a gentleman who had a house in Foster City, which is a suburb that's about 20 miles from here. He paid all cash for the house, and he paid all of the property tax bills and expenses through his bank account in Hong Kong. So when he died, he did not have an ITIN, and we did obviously have to file an estate tax return because he was well over the $60,000 threshold. It took I think, almost 9 months to just get an ITIN for him. There is a procedure that you can go through with the IRS, but it takes a long time to go through the procedure. But, we had no way of really filing the estate tax return until we were able to get an ITIN for him.
So an ITIN is a barrier to getting that. That has to be you have to get that before you can file a 706 NA. And what about, aren't there treaties that the U.S. has to maybe offer some type of relief from this $60,000 exemption amount from the estate tax?
There are treaties with a certain number of countries, but it's not with that many countries. I'm probating. No, let me take that back because that one didn't work. Yeah, there are countries where there are treaties, but it's a handful of countries where that's done. What typically happens is, rather than a treaty that would completely exempt a person from U.S. taxes, it's a treaty where they look at what the relative tax rates are in the two countries. So, for example, we have a treaty with England, with the UK. Our estate tax, our estate tax rate is 40% over $1 million worth of assets. The UK estate tax is set at a lower number than that. So in the UK, I think that if you've got far less than $1 million, let's just say that both of them started. Let's for comparison purposes say both started $1 million. So in the US, the estate tax would be 40%, 400,000. Let's say that in the UK, the rate would be 26%, so 260,000. The way that the treaties work is similar to the way that they work for income tax when you've got a person who has to pay income taxes in two countries. The rule would be that the first $260,000 would go to the UK, and the remaining $140,000 would be paid over to the IRS in the United States, so that overall the person didn't pay more than 40%, but they split who gets which portion of the amount of money. So flip that and say that the U.S. tax rate was 40% and England's were 45%. The first 40% would go to the U.S. and the remaining 5% would go to England.
I had an estate where the decedent was from Canada, and the U.S. and Canada have an estate tax treaty. And in that tax treaty, it apportioned U.S. Situs assets and worldwide assets. And so if your U.S. Situs assets were 30% of your estate of worldwide assets, then you got 30% of the exemption amount that a U.S. citizen would have. And so that's how the Canada tax treaty worked. And there's a difference between income tax treaties and gift and estate tax treaties. And so you have to see which, and there aren't many countries that have an estate tax treaty with the U.S.
Correct.
One of the countries that does not have an estate tax treaty with the United States is Mexico. And so a lot of times that's a big issue with persons that are Mexican citizens, Mexican domiciliaries, and that have U.S. Situs property. Besides real estate, what other things might be U.S. Situs property?
So back to law school, tangible personal property versus intangible personal property. And again, it gets slippery. Piece of art. Well, actually, let's use a car because that's much more, let's assume that you're a car and you've got a Lamborghini or a, Maserati or a McLaren.
What do you think? You think the most high end? Me, I'm kind of like, oh, that old Datsun, that one, the cool Datsun. Oh. We've got to make it taxable, right? Let's dream, Janet.
If you've got that high end car, let's call it a Lamborghini. If you've got that high end car and you keep it garaged here in the United States, it's a U.S. Situs asset. On the other hand, if you have it shipped to your place over in Italy, and that's where you keep it, it's no longer a U.S. Situs asset. right? Because
Yes.
it's not, I mean, situs is just a fancy Latin word for where is it located? Where is it physically located? And if it's not physically located in the United States, it's not a U.S. situs asset. So that's easy for the things that we can basically feel and touch. But now we get into, well, what about that patent for that software program that I invented? I'm getting royalties in the United States, but I've moved back to my home country. Is that a U.S. situs asset or not? And the answer is probably not, because it is an intangible. It's not the royalties that we look at, but it's the source of those royalties, which is a patent. A patent by its very nature is an intangible asset, right?
Yes.
So it produces royalties. It's the apple tree that produces the apples. Where's the apple tree located? We don't care where the apples fall. So that is not a U.S. situs asset. The other thing that we run into frequently is shares of stock. And now it really gets complicated, because now we've got a difference not only between tangible and intangible, but gift tax and estate tax. They're not as unified as you might think. So let's say that let's keep it modest, I have 100 shares of Apple stock. And I'm a non-resident of the United States, but I opened up a brokerage account over here and I purchased 100 shares of Apple stock. Apple stock is an intangible asset, right?
Yes.
Therefore, under the rule that I said, it should be considered not situs in the United States, correct?
Yes.
Well, for gift taxes, that is true. But for estate taxes, the IRS does a 180 and says, oh, but it's stock in a U.S. corporation, and so we are going to treat it, and we are going to tax it if you die owning it. So if I gave that 100 shares of the Apple stock away the day before I died, it would not be a taxable gift. But if I gave it away pursuant to my death, the will, trust, and testate, it would be considered a U.S. situs asset for U.S. estate tax purposes. And there's a whole laundry list of things that, again, and I want to make it clear, these rules of what the situs is only apply to non-green card holders and non-U.S. citizens. If you're a U.S. citizen or a green card holder who intends to be domiciled in the United States, the IRS doesn't care where the asset is located. You could have taken it up to Mars. I guess we haven't gotten that far yet. We're still trying. But it could be located on Mars, and it is still a U.S. situs asset, or actually, we don't care if it's a U.S. situs asset or not. It's still owned by someone subject to IRS jurisdiction on worldwide assets. So it will be something that counts toward the estate tax exemption.
What about a bank account, like cash in a bank account, checking, savings?
Again, a little bit slippery. If it meets certain qualifications for being in a bank, it can be considered a non-U.S. asset. But let's take the same cash. Let's say you've got cash in a checking account at a bank or at a credit union, and you decide to move that into a brokerage account. You've opened up a brokerage account with, one of the brokerage firms. I won't say, doesn't matter which one. And you've got that same cash sitting in a brokerage account because you intend to invest it in some stock, but you haven't done so yet. Cash in a brokerage firm does not qualify as not being in the United States for estate and gift tax purposes. It is not in a bank account by definition.
Okay.
It's a brokerage account, not a bank account.
But what if it's at a bank, a bank down the street, that kind of a bank, and a checking account?
Yeah, I'm going to stop you for a minute. I honestly don't remember the exact distinction. It's if it's. I think my recollection is that if it's in your name, it is not subject in tax. I think this is the answer. If it's in your name, it's not subject to taxation. But if you take that money and write a check to someone, it is now subject to estate or gift taxation.
Sticky rules.
Very sticky rules.
Yeah. Okay.
Yeah. And frankly, I don't like talking about them from memory because there's enough distinctions between them that it's a really, really easy way to make a mistake. So this is probably a good time to say that, what I'm talking about is general and it's not meant to be legal advice.
Yes. Yeah. Not specific to any client. Yeah.
Exactly.
But what's great is this is giving us a good idea of how to spot the issues and try to understand, I need to reach out to someone with more knowledge about this than I have. Maybe I reach out to Janet and talk to Janet, have a conversation with Janet and see if she might want to co-counsel on something like this.
Right.
Mm-hmm.
And I'm happy to co-counsel with people.
Cool. What about sometimes we have, even on a non-taxable estate, something called a transfer certificate. What is a transfer tax certificate from the IRS?
So the transfer tax certificate is you need it in two cases, I guess, would be the easiest thing to say. If you are a non-resident of the United States and you have an account in the United States, financial institutions will require that you get a transfer tax certificate before they will release the funds to your heirs. So that one's fairly straightforward. You're here from Canada, you've got a US bank account, you've got, $30,000 or $40,000 in it because, you're a snowbird and, spend the winters in Arizona and you want to have US cash that you don't have to worry about converting your Canadian dollars into US dollars. The IRS says that if you die, before the bank will release the money to you, you have to have what's called a transfer tax certificate. That one is fairly understandable and straightforward because of the low $60,000 exemption. The one that's a little bit sneakier, and I was sharing this with you earlier, I have a couple who are both U.S. citizens, lived in Hong Kong. They have decided to move to Hong Kong. She kept their U.S. citizenship. She passed away recently. She had worked all of her working life in the United States and had an IRA that has about $500,000 or $550,000 in it. Her husband, who is a U.S. citizen, is named as the beneficiary on that account. So the common advice on that would be, Sam, to do a spousal rollover, correct?
Yes.
Easy peasy. Call up the broker and say, my wife passed away. I want to do a spousal rollover. Send me the paperwork. Well, not so fast. Because even though they were U.S. citizens, because they were living outside of the United States, the brokerage firm is requiring a transfer tax certificate. And it is on the IRS website. I sent you a link if anybody wants to take a look because they go, what? I don't believe that the IRS would do that. But it is on the IRS website. And in order to have that money released, you need to provide either a State Department Form DS-2060, which is the report of a death of a U.S. citizen abroad, or a death certificate and a copy of the photo page of the decedent's current U.S. passport or other proof of U.S. citizenship, and an affidavit written under oath before a notary that is signed by the executor, administrator, or personal representative of the estate, and includes a listing of all of the worldwide assets of the decedent, and says that, then basically swears to the IRS under penalty of perjury that there was no estate tax owed. Plus, you have to file an inventory of all of the assets that the decedent owned. Plus, if there were any estate tax filings required in the country where you resided, you have to provide a copy of that. And you have to provide a copy of the decedent's U.S. will or other testamentary instruments. All of that needs to be sent to the IRS. And pre-COVID, They said, once you send that in, it'll still take us 6 to 9 months minimum to issue a certificate that says, yes, financial institution, you can release the money to the person or the assets to the person that's asking for them.
Wow. I want to highlight a couple things here. Number one, this is for U.S. citizens.
Yep.
Even if you're an American, if you live outside of the United States, they can require this of you.
Correct.
Okay. So, and this is what would ordinarily, I mean, you could have a beneficiary designation.
Yep.
On your retirement account. And normally you just show them the death certificate, you get the money. Here, you have to get this transfer tax certificate from the IRS to get your money.
Yep. That is correct.
And it could take a long time.
Yep.
It could take a really long time to clear this up.
Yep. How are you planning to pay the mortgage next month?
Wow. Right. Yeah. I mean, if you need that money to take care of this, you're not going to be able to use this money for that purpose. Wow. That's really incredible.
Yeah. And as you know from what I stated, I mean, what even in a non-taxable estate, you have to produce documentation that's almost as onerous as having to do a 706.
Yeah. Yeah. And this could be, is this for non-resident aliens or just citizens?
Well, again, I don't have the one for non-resident aliens up. I've just got the one for U.S. citizens. There is an equivalent web page on the IRS website for non-resident aliens who have to get transfer tax certificates.
But it's basically the same as the requirement for a non-resident citizen.
I think I would have to look. There might be some
differences.
Yeah, there are some differences. Well, and again, remember, if you're a non-resident alien, you have to most likely do a 706. Because you probably got more than $60,000 worth of assets.
I see the difference because really for a non-resident alien, because the exemption amount is so low, most non-resident aliens that have U.S. Situs property are going to be filing a 706 NA. Here, we're talking about a transfer tax certificate from the IRS for citizens of the U.S. that live abroad.
And who may not have a taxable estate. They may, they may only have, they may only have $500,000, $600,000, $700,000, including, again, this includes, my clients who lived in Hong Kong or who live in Hong Kong still have a house in the United States.
Yeah.
But it's not their principal residence.
But that house doesn't require this transfer tax certificate. It's a financial account that requires this.
That's true. But what do you think would happen if they tried to sell that house? What would the title company be looking for?
Oh, do they really? Because then the estate would, even if they lived abroad, would have to, when they sell this property, put that money in a bank account.
Right. And the title companies are going to want to make sure that the house can be transferred. Right?
Yeah, that could hold things up. Wow. That's important information. I will include a link to the IRS's website that you gave me in the show notes for our listeners to be able to look that up themselves as well. And I find that there's some confusion. There's some states that have this and some other countries, but there's a difference between an estate tax, which most people are familiar with, versus an inheritance tax. Can you shed some light on the difference between those?
Yeah, the simplest way that I find to explain the difference is that the estate tax is really paid by the decedent, it's paid out of the assets that belong to the decedent. An inheritance tax is paid by the recipient. So let's assume that I've got a state where I've got, again, let's call it $2 million. And I've got one kid that lives in the United States, U.S. citizen living in the United States. Well, actually, I guess for today's world, if we're dealing with estate tax, we've got to have more than a $15 million estate if it applies to a U.S. citizen. But let's assume, or to a green card holder. But even though the estate might not be subject to estate tax in the United States because it's well below the $15 million, if you're living in a country that has inheritance taxes, and let's say you're sending $500,000 to that country, that is, so, and when it comes into the country, the person who's receiving the money is required to indicate what the source of the money is. So in this case, it's an inheritance from Great Aunt Martha in the United States. That is subject to inheritance tax, even though it's not subject to estate tax in the United States. Where it gets particularly messy, shall we say, is in the larger estates where, for example, there's been estate tax paid in the United States, and then the recipients also have transfer tax. None of the treaties, to the best of my knowledge, have an offset for estate tax to inheritance tax issues. So you could very well end up paying an estate tax in the United States and also have the recipients be required to pay an inheritance tax when they receive that money in the other country. And please don't ask me which countries have inheritance taxes because I don't have it memorized.
But I think the important thing to understand here is that the estate tax is different from an inheritance tax.
That is correct.
The taxpayer is different. And if the U.S. has an estate tax treaty that offers relief with another country, that may not be applicable to the inheritance tax.
It probably will not be
applied to the inheritance tax.
Thank you. Applied to the inheritance tax.
That's a huge distinction to understand.
Yeah.
And so I find that, communicating often and early helps to give an understanding that maybe people don't like that situation, but at least they will accept it if they understand early on. And it avoids well, no one told me.
Right.
Yeah.
Right. Well, unfortunately, the person that he's told is probably deceased. So the issue is, how do you let the beneficiaries know? And, again, just from a practical standpoint, it would become very unfair. What if you've got two children, one of whom lives in a country that has a transfer tax and one of whom lives in a country that doesn't? Just by virtue of where they live, one may end up receiving a substantially greater or lesser inheritance than the other one.
Yeah, right. No, that makes sense depending upon the rules of that country.
Yep.
Yeah. If one of our listeners has an estate that might have international tax issues, what advice would you give them?
Well, I think they need to speak to somebody who is familiar with the nuances, shall we say, of planning for an international estate. I always tell people, and actually this is a very common misconception. I've had many people come to me saying, hey, I've got property in, you name the country, Hong Kong, China, Mexico, Canada, England, and I need you to plan my estate. Well, I can't really plan your estate for assets that are not located. I can plan for the estate tax impact, and I can advise you about that, but I can't create a trust that is going to be enforced in a different country. So in many cases, we end up co-counseling with an attorney in that other country, and we're just trying to coordinate the plans so that our plan doesn't cancel out their plan or vice versa. But, I say it's very obvious in trusts. I'll see a trust that names my sister who resides in Canada to be the trustee of my U.S. trust. That's one thing that comes up frequently. Or I hereby transfer my condo in Paris to my U.S. trust. Well, good luck trying to get the French authorities to accept a U.S. trust. They don't even have a concept of trust in France. So, it happens. It happens frequently, and it doesn't work. That's a great way for a plan to fail.
Even in a country that has trust, my wife is British, and she has a flat. We would call it an apartment in London,
right.
And she owns it. And she owns the lease on it, but that's equivalent there. And when she was making her estate plan in the UK, I mentioned to them about a trust, and they said, "Oh no, you don't want to do that." And he went on about why You don't want to have a trust under that situation there because she was non-resident and tax implications. And so even in a country that has the concept of a trust, not even a civil law country, this is something that is not a one size fits all for all situations in all countries for a trust.
Correct.
Yeah.
Correct. And by the way, the other common mistake that I see, and I don't know if you see it as much in Southern California, I think probably people in Northern California, Oregon, and Washington may see it more, is attorneys that want to put Canadian real estate into the name of a trust. Again, going back to, this actually puts another, layer on estate tax versus inheritance tax. Canada doesn't really impose an estate tax or an inheritance tax per se. They impose a transfer tax. And the mere fact that you move an asset out of your name and into the name of a trust triggers a transfer tax in Canada. So if you take your document up there and you manage to do it, or if your lawyer says, well, you've got property in Canada, you need to transfer that into the name of your trust, and you do it, you are going to be hit with a transfer tax that I believe is something equivalent to about 15% of the fair market value of the asset that's being transferred. Again, don't quote me on the percentage, but I think that is the rate that I recall seeing.
Some really bad unintended consequences can happen if you just start doing things willy-nilly. Yeah. Well, you have been fantastic, Janet. Thank you so much for coming on the podcast and telling us all this information.
Well, thank you for having me. It was a pleasure.
Sure thing.
And we'll get together when nobody's working and I'll tell you a couple of my that'd
Would love to. Actually, that'd be kind of fun to record some of that stuff. We'll have you back on. Well, that's a wrap for this episode of Probate Notes. And whether you're an attorney, paralegal, fiduciary, or real estate agent, remember that probate doesn't have to be overwhelming. With the right approach, it's a process you can guide with confidence. If you found this episode helpful, here's a few things you can do to stay connected and keep learning. Subscribe to Probate Notes on your favorite platform, rate and review the show, and share this episode with a colleague who works in probate. You never know who could use a fresh framework. Thanks for spending time with me today. This is Sam Price, and as always, keep your filings clean, your probate notes clear, and I'll see you next time on Probate Notes. Thanks.